Good evening. Welcome to the Rules Committee. Today, the committee will consider H.R. 806, the Ozone Standards Implementation Act of 2017. Ozone levels are down 1/3 since 1980 and continue to trend downward, but states are faced with implementing overlapping and stringent new standards simultaneously. H.R. 806 facilitates efficient state implementation of ground-level ozone standards. Specifically, the legislation phases in implementation of the 2008 and 2015 ozone standards, extending the date for final designations and aligning permitting requirements with the new phased implementation schedule. This legislation is necessary to ensure the efficient implementation of ozone and other air quality requirements in a realistic time frame. I'd like to welcome the gentleman from Illinois to this panel, Mr. Shimkus, Chairman of the Subcommittee on Environment in the Energy and Commerce Committee, and the gentleman from Texas, Mr. Olson, the Vice Chairman of the Energy Committee. I'd like to also welcome the gentleman from New York, Mr. Tonko. Gentlemen, we are delighted to have you here at the Rules Committee. We're all anxiously anticipating your testimony. Without objection, everything you have in writing will be entered into the record, and the chair would recognize Mr. Hastings for any comments that you may have.
Mr. Chairman, I welcome our witnesses. I do not have any questions or comments at this time.
The chair thanks the gentleman. Gentlemen, I believe each of you has testified before the Rules Committee before. Chairman Shimkus, you're recognized for as much time as you need.
Thank you, Mr. Chairman. Mr. Chairman, we moved a similar version of this legislation through the House last year, and it remains important for our efforts to boost American employment and economic growth. H.R. 806, the Ozone Standards Implementation Act of 2017, is critical, removing unnecessary barriers to the planning and permitting of new and expanded manufacturing facilities and to related economic activity, especially for building out America's infrastructure. This act provides a sensible path forward for continuing to reduce ozone levels while avoiding the unnecessary economic damage that EPA's complicated regulations would inflict. The act will facilitate more efficient implementation of existing ozone standards and other National Ambient Air Quality Standards, or NAAQS. For the existing ozone standards, the act would phase in implementation of the 2008 and the 2015 ozone standards, extending the date for the final designations from the 2015 standards to 2025. And it will also align permitting requirements with the phased implementation schedule. For NAAQS process reforms, the Act would change the mandatory review of the National Ambient Air Quality Standards from 5 to 10 years, while allowing the EPA administrator discretion to issue revised standards earlier. It would authorize the EPA administrator to consider technical feasibility as a secondary consideration when revising the National Ambient Air Quality Standards. I hate acronyms, that's why I keep saying that. Ensure that the EPA administrator, prior to revising the National Ambient Air Quality Standards, obtains advice from the agency's independent scientific advisory committee regarding potential adverse effects relating to the implementation. Ensure that the EPA administrator ensures timely implementation regulations, guidance when revising the NAAQS. Ensure that for certain ozone and particulate matter non-attainment area, states are not required to include economically infeasible measures in their plan. Ensure that states may seek relief with respect to certain exceptional events, including droughts, and direct the EPA to submit reports to Congress regarding the impacts of foreign emissions on NAAQS compliance and related matters, including the agency's current petition process under Section 179B of the Clean Air Act and the ozone formation and effective control strategies. Finally, reforms limit the applicability of particular sanctions and fees on certain ozone and particulate matter attainment areas if states demonstrate the reason for non-attainment is for emissions beyond the state's regulatory control. This provision, which we developed based on testimony from state regulators, helps areas that are doing the most work to clean their air and avoid the unnecessary and burdensome sanctions which harm their ability to achieve economic growth. The Act also clarifies that no additional funds are authorized by this legislation. The Congressional Budget Office has estimated costs associated with the bill to be $2 million. These relate to required analysis that will assist EPA and state regulators in better understanding background ozone and cost-effective implementation strategies. This act streamlining reforms, however, reduce agency resources needed to implement the air quality standards. The act ensures that we can continue to improve air quality and reduce burdens on our economy. I urge my colleagues to support H.R. 806, Ozone Standards Implementation Act. And before I yield back, I just want to, Pete Olson is the primary sponsor of that, so he's here to help me when we have some questions. Yield back my time. Thank you, Mr. Chairman.
Thank you, Chair, and to you, Mr. Chair, and to the ranker and the entire membership of the committee. Thank you for allowing me to testify today on H.R. 806. I wish I was here under different circumstances. This year, the Environment Subcommittee has built a sound and good track record of bipartisanship, and I'm thankful for that. We reported a bipartisan bill out of the full committee to reauthorize EPA's Brownfields program on a voice vote. On an issue near and dear to Chair Shimkus's heart, we reported a nuclear waste bill by a vote of 49-4. And last week, we voice voted my top priority out of the subcommittee to reauthorize the Drinking Water State Revolving Fund and invest in our nation's drinking water infrastructure, which is on the path to being another bipartisan success story. So grateful for that news. Unfortunately, the same cannot be said about H.R. 806, the Ozone Standards Implementation Act of 2017, which was not supported by a single Democratic member of the committee. The Clean Air Act has driven important progress in improving our nation's air quality and public health. Under the law, EPA is required to set, as we know, National Ambient Air Quality Standards, or NAAQS, for certain pollutants that endanger public health and the environment, including ozone. These health-based standards are the cornerstone of the Clean Air Act. EPA sets NAAQS at levels sufficient to protect the public health, essentially the level of ambient air pollution that is safe to breathe. While costs are not considered in establishing these standards, costs can be and are considered in developing plans to achieve the necessary pollution reductions to meet the standards. Under the statute, EPA must review each NAAQS every 5 years and make revisions as appropriate. As I've stated before, H.R. 806 takes an everything-but-the-kitchen sink approach to weakening the Clean Air Act. The bill would delay implementation of the 2015 ozone NAAQS by up to 8 years. It would extend the review period for all criteria air pollutant NAAQS, not just ozone, from every 5 years to every 10 years. And it would change the long-standing criteria for establishing an air quality standard from one that is based solely on protecting public health to one that includes consideration of the technological feasibility of that standard. I know a number of amendments have been submitted to address some of these concerns. When I was growing up, the public did not have a great awareness about air pollution. We just simply called it smog. But today, there is robust scientific and medical evidence that ozone, particulate matter, and other pollutants can have very serious health effects, particularly on vulnerable populations, like our children and our elderly. Delaying or weakening those standards goes against the growing body of scientific evidence that demonstrates that we need to continue to strengthen the standards if we want to truly protect public health. Protecting public health and growing the economy are not mutually exclusive. In fact, just the opposite is true. Healthier people will allow our economy to thrive. That is why our economy has tripled, while we have reduced major air pollutants by 70% since the enactment of the Clean Air Act. Healthier people means fewer sick days, hospital visits, and premature deaths, all which lead to a more productive society. History has shown that meeting these health protective standards is achievable, so I cannot support the bill before us today. It would undermine the goals of the Clean Air Act and slow down, if not roll back, the progress our nation has made on improving air quality. Short of reporting an open rule, I urge the committee to make all amendments submitted in order. I have submitted an amendment to remove the technological feasibility section to ensure that EPA continues to consider only health-based factors when determining what level of pollution is safe. Ms. Castor has submitted an amendment to halt implementation of the bill if EPA's independent advisory panel, the Clean Air Scientific Advisory Committee, finds that it would increase health risks to vulnerable populations, including children, seniors, and pregnant women. And Mr. McNerney has offered a couple of amendments that get to the real issue that is constraining state and local governments from meeting today's standards, and that would be a lack of resources. Section 6 of the bill actually blocks any additional funds from being used to implement this act. State and local governments rely upon federal assistance to achieve healthy air quality for their residents. Unfortunately, this prohibition, coupled with drastic proposed cuts to EPA's budget, will only further undermine the efforts by regions with the poorest air quality as they work to meet these standards. These are just a few of the amendments that have been submitted, and I thank you again for letting me appear before the committee today. Once again, I would encourage you to make all Democratic amendments in order, and I'm happy to answer any questions that the committee might have. With that, Mr. Chair, I thank you and yield back.
Gentleman yields back, Chair. Thanks, the gentleman. Chair recognizes the gentleman from Texas, Mr. Olson, Vice Chairman of the Energy Committee and the author of the bill. As I understand, you're recognized.
Thank you, Mr. Chairman. Thank you to the members of the Rules Committee for having me here to talk about my bill, H.R. 806. I'd like to express some gratitude, first of all, to some of my original co-sponsors. Whip Steve Scalise is a co-sponsor, as is Leader Kevin McCarthy. It's a bipartisan bill. On the Democrat side, we have Henry Cuellar from Texas and Sanford Bishop from Georgia. When I first moved to Houston in 1972, I couldn't see downtown but for a few days. My home down there by NASA, about 25 miles southeast of downtown Houston, Texas. I now live in Sugar Land, about 25 miles southwest, and I can see downtown almost every single day of the year now. The year before was horrible. It was smoggy. Now it's much, much cleaner. We've improved our air dramatically with explosive growth. Raising my kids in the heart of America's energy and petrochemical epicenter, I don't want to go backward. I want cleaner air. I want healthier air. So let me be clear. H.R. 806 is about cleaning up our air. It's not about going backwards. It's about charting the best path forward. This bill moves forward by creating a path to have higher air quality and more new infrastructure and more jobs. It provides long overdue reforms to the process by which EPA sets and implements the ozone standards. Ozone standards are important, but they have to be achievable when we implement them. Without that, it adds burdens to state and local governments and kills economic growth in our communities. It even hurts highway construction because there may be a loss of highway funds being a non-attainment for ozone. As we've seen, EPA has a terrible track record of providing late and sloppy tools that hinder a smooth process for local officials. Thanks to lower standards, we have improved America's air quality, which means right now we're close to a point where lower standards are hard to achieve and maybe out of our control. Naturally occurring ozone, exceptional events like forest fires, add challenges to compliance. My ozone bill will help the approximately 350 counties in America that are currently non-attainment by allowing them to fully implement the 2008 standards before imposing new paperwork and plan requirements, most recent 15 standard. Ozone has declined by about 1/3 since 1980. And the 2008 standards and other regulations already in place will ensure continued improvements for the next 8 years until the new standard can be implemented. This bill also takes the first step to making sure we're penalized for ozone we can't control. EPA admits that half the ozone in America comes from what's called uncontrolled sources. It's ozone that occurs naturally, ozone that crosses the oceans from Asia, ozone that comes from our neighbors to South Mexico when they burn their crops. This bill makes sure EPA looks at that and takes that into account. This bill makes some long overdue reforms to the 46-year-old process for setting the NAAQS standards. When it was written, there was a lot of room to make changes to clean up our air. The progress we've made means we have to work harder and smarter to improve our quality in a meaningful way. This bill improves this process, and I humbly ask this committee to bring this bill to the floor for a vote. Thank you. I yield back.
Chair thanks the gentleman. Chair thanks all of our witnesses. Chair observes that he's going to have ample opportunity to talk about this on the floor tomorrow. So recognize Mr. Cole from Oklahoma for his questions.
I thank the gentleman, but actually I have no questions. Just want to say hi to my good friends. Good to have all of you here. Yield back.
Gentleman yields back. Chair thanks the gentleman. Chair recognizes the gentleman from Massachusetts.
Well, thank you very much. And I think many of us actually feel that this is a step backwards, and so we're very, very concerned about it. But let me ask a question about process. I'd ask you if you favor an open rule, but we don't believe in those on this committee anymore, so you're probably not going to, probably it's a hopeless cause to think that we might. But there's some interesting amendments that have been offered here. Would you have any objection if they were all made in order?
I'll leave that up to the Rules Committee to make the decision of which amendments are meritorious or not.
Well,
I mean, we've debated our own amendments, very minimum or similar, that came through the
you
committee.
don't have an opinion based on principle as to whether or not we ought to deliberate?
If I was on the Rules Committee, I may have a position, but I'm not.
I have a position about things that come out of your committee.
I know, that's the problem. That's the problem.
I think it's a lot, you know, so, yeah, I hope that they're made in order because, again, I think that there's some deep concern over the content of these legislation, as Mr. Tonko pointed out, and I think we ought to have an opportunity to have these individuals who have brought thoughtful amendments to the committee make them in order. And I yield back my time.
Gentleman yields back. Chair thanks the gentleman. Chair recognizes the gentleman from Washington State. Gentleman does not have any questions. The gentleman from Florida. The gentleman from Oklahoma. The gentleman from, I'm sorry, Colorado. The other gentleman from Colorado. And the gentlelady from Wyoming is recognized. Well, thank you, gentlemen. You've obviously done a very good job of presenting the data. We will, right. But we can excuse this panel, correct? Okay, so this panel can be excused, and we will hear from what witnesses wanting to offer their amendments. Thank you.
Chair, thank you.
Mr. Cooper, and any members wishing to be heard on their amendments. Chair welcomes you to the Rules Committee. Anything you have in writing, if you would make it available to the clerk, and yes. It pains me, but yes. Whatever your preference is, Mr. Polis, I was prepared to recognize you from the dais, or so no one is more senior than Mr. Cooper. So, Mr. Cooper, without objection, you're recognized to be heard on your amendment.
Thank you, Dr. Burgess and members of the committee. I have an amendment to H.R. 806. I think it would improve the bill. It's basically a states' rights amendment. It would allow states at their option to include consideration of local land use controls in their state implementation plan. This also would, I think, give a chance to improve state and municipal and urban relations. The principle here is one I discovered representing the city of Nashville, Tennessee, and this would do nothing for Nashville. It's too late to help us. But what we encountered was that even the capital city in a state has almost no input when it comes to the state implementation plan. So I think our amendment would clarify an ambiguity that's currently in the law. Today, the Clean Air Act only limits EPA's authority to require land use controls as part of the SIP, or the State Implementation Plan. But some have taken that principle further and said that the Clean Air Act prohibits including land use controls. And in an area like Nashville, where we are in a natural bowl, it's very tricky when it comes to regulating air quality. We get concerned about an individual company coming in on kind of a first-come, first-grab basis, and then they pollute enough so that we become a non-attainment area. That limits all future growth possibilities in our area. And we're a state capital, and how is this fair? So I think it would help the bill immensely if we could allow states to voice their legitimate priorities, including local priorities with land use planning. Otherwise, land use doctrine all over the country is completely overridden. So to me, this is a way of improving the Clean Air Act and helping states have more of a voice in the process. So I would urge inclusion of my amendment as H.R. 806 is considered.
Chair thanks the gentleman. Gentleman from Colorado is recognized.
Thank you, Mr. Chairman. Since this bill is about enhancing the Clean Air Act, I've offered an amendment to close a very glaring loophole that harms the air in my state and many other states with significant extraction industries across the country. My amendment is based off legislation that I introduced with several of my colleagues called the BREATHE Act, which would close the oil and gas industry's loophole to the Clean Air Act's aggregation requirement. Currently, oil and gas operators are exempt from the aggregation requirement under the Clean Air Act. Under the aggregation requirement, small air pollution sources that cumulatively release as much air as major polluters instead aren't even counted. They're not counted as major sources. Oil and gas is exempt, and even though the aggregation requirement is intended to protect the public from small air pollution sources that might individually seem harmless, but when you have 20,000 operating wells in a limited area, the profile of that is the equivalent to several large source polluters, which doesn't mean it's banned or anything like that, but means you can't round it down to zero. It's significant in the aggregate, so we need to remove this exemption. The oil and gas industry doesn't currently have to aggregate its small air pollution sources, even though the production, processing, and storage can release even larger amounts of natural gas in the aggregate, larger amounts of air pollutants in the aggregate than a large site. So my amendment would also add hydrogen sulfide to the Clean Air Act's federal list of hazardous air pollutants. It was originally on the list. The Clean Air Act completely exempts hydrogen sulfide currently. We would add that back. The amendment ensures that the industry takes measures to avoid the release of hydrogen sulfide by adding it to the list of hazardous air pollutants and by listing oil and gas wells as potential sources. So my amendment would simply ensure that oil and gas operators operate in the same way as any other land use that affects our air. And we have to make sure that, particularly when in the aggregate, they can have a very profound effect, that we look at them through the Clean Air Act, and that's what my amendment to this bill would do.
Chair thanks both the witnesses. Let me just recognize myself for questions. Mr. Cooper, do you have is there like a practical application that you have in mind with your amendment? Is there a specific instance that has occurred?
Well, as I say, it's too late to help Tennessee at this point, but for all 50 states, I think it's important to respect state rights. And if you read the text of my amendment, it's very simple. It's one sentence. It says that states may choose to incorporate local land use policies into state implementation plans. Because we have to state this affirmatively, because today states apparently feel that they're banned from including local land use concerns. And I think that is gross federal overreach to tell a state they cannot consider local land use priorities, especially when you have geographical unusual circumstances like we have in the Central Basin in Middle Tennessee, which is largely surrounded by hills which tend to contain especially summer smog. So this creates a situation when we're not allowed to consider local land use priorities where one or two companies can come in and grab all the potential that we have in our area to create industrial jobs. And that doesn't seem to us to be fair. So it's really gross federal overreach I'm trying to stop here by enabling more states' rights and consideration of local priorities. What could be wrong with that?
I thank both of you for your testimony. Gentleman from Oklahoma.
Thank you. It's good to see both my friends. One I get to see quite a bit up here anyway, but no questions, Mr. Chairman. Yield back.
Gentleman from Massachusetts.
I thank you for being here, and I certainly support making your amendments in order. Yield back.
Does any other member seek recognition on the amendments to H.R. 806?
Only to echo Mr. McGovern's sentiments and share the belief that both these amendments are excellent and should be made in order, Mr. Chairman.
All right. Chair thanks the gentleman. That concludes our, this panel. Mr. Flores, did you wish to offer an amendment? Okay. So this concludes the hearing portion of H.R. 806. The committee will reconvene right before votes, subject to the call of the chair. That likely will be at 6:20 p.m. Till then, the committee stands in recess.
Rules Committee will come back to order, and thank you very much for allowing the slight delay as we prepared the rule. We're now coming back in to speak about H.R. 806 Ozone Standards Implementation Act. Chair will be in receipt of a motion from the gentleman from Georgia.
Mr. Chairman, I move the committee grant H.R. 806, the Ozone Standards Implementation Act of 2017, a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment and amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-26 and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, shall not be subject to amendment, and shall not be subject to a demand for the division of a question. The rule waives all points of order against amendments printed in the report. And finally, the rule provides one motion to recommit with or without instructions.
I thank the gentleman from Georgia for the motion. I'd like to yield myself just 1 minute. This structured rule will provide a 1 hour debate, which will be providing Energy and Commerce that opportunity to debate these issues. Makes in order 6 Democrat amendments and a motion to recommit. So I think it's a pretty balanced opportunity for both sides here. Is there amendment or discussion to that, gentleman from Massachusetts?
Yeah, I just was curious. Mr. Cooper was up here a little while ago who testified, and I thought had made a compelling case for his amendment. And if I'm not mistaken, I think his amendment was germane.
Yes, as a matter of fact, it probably was. And what we've tried to do is to bring together what we saw as several different amendments and wrap them into the ones that we did make in order.
So is his in one of these?
In my opinion, the sections that we have made in order are around those issues. And while I was not here for it, I reviewed this morning, but does someone want to provide me more content on that?
It's not apparent to me, but
Not apparent.
maybe it's in the invisible link somewhere here. Whatever.
Thank you very much. Mr. Cooper clarifies existing law that state implementation plans can incorporate local land use policies. Thank you very much. We believe that that would be, or felt like we would be included within the motion to recommit. And perhaps now that I see it, I'm not saying that it is. Okay. Okay, the answer is that land use policies were not included in the air quality standards.
But it's germane, and I think, well, anyway, I think,
And that we would welcome him coming back through committee. And that the committee indicated that that was not considered an ozone standard. It is within the purview of the germaneness, but not in terms of the debate that would take place.
Would the chair repeat what you said? that
Yes, sir.
land
It is
use-
about land use.
All right.
And land use is a huge issue. And we did not address land use issues in the bill. It was ozone related. And that if the committee chooses to do a land use policy, even though it might be germane, that is not what the bill was about. It was concerning ozone. So the committee has said if you'd like to come back to the committee and we
so
do
your-
land use.
So your
issues.
position, Mr. Chairman, is that the use of land would not be a contributing factor to ozone?
No, sir, I don't think that's what they were saying. What they were saying is they were dealing with the subject of air quality from, I have not debated these issues, but as opposed to land use policy.
Well, I would just like to go on record as saying if you were to put manufacturing in the use of land at some point, the pollutants are likely to come from it. So I believe, and why I was very supportive of Mr. Cooper, is he was not here arguing about Tennessee. He was saying that this is something that should be considered by other states. He thought it was too late for his own. But be that as it may, we'll get another chance to vote on it.
Well, I think that what the committee's trying to say is that I believe they are open to land use policies, rules, regulations, Supreme Court cases, takings, issues that deal with agricultural issues, also including conservation issues. I think they're interested in doing that. They did not view that's what the bill was about. That's solely not to beat Mr. Cooper up at all.
I appreciate yours.
Yes, sir. And I'm sorry, I was thinking about another one when we were doing that. Thank you very much. Gentlemen wish to further. Did the gentleman have a motion?
No.
Gentleman does not have a motion. Thank you very much. Is there further discussion or amendment to this? Hearing no further discussion and no amendments placed upon the table, we will now vote on the motion from the gentleman from Georgia. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it. The ayes have it. Gentleman, ask for a roll call vote.
Mr. Cole. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Mr. Byrne. Mr. Byrne, aye. Mr. Newhouse. Mr. Buck. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Ms. Slaughter. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. Nay. Mr. Hastings, no. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk report the total.
6 yeas, 3 nays.
The motion is agreed to, and accordingly, the gentleman, Dr. Burgess, will be handling this for Republicans.
And Mr. Polis with the Democrats.
Mr. Polis will be handling this for
And Mr.
Democrats.
Chair, I just want
Yes, sir.
to,
Yes, sir.
you know, just a response to what you just said about why the Cooper amendment wasn't in order. It just seems like the standards change, because, I mean, last week we did a National Defense Authorization Bill, and there was a amendment dealing with the rights of transgender individuals that I don't think had anything to do with what we would consider the normal subject matter of the Defense Authorization Bill.
Well, I'll be glad to discuss that if you'd like to get into it.
No, I'm just saying, but that, you guys put that in there, but, you know, I recall lots of.
But it was the issue that is directly for the arms, the Pentagon, that's a $3.6 billion issue.
Well, but I think one can make the argument that this has an impact on.
Well,
On this,
as a matter of fact,
I'm
I
just saying,
do
but I mean,
understand.
the idea that-
I get what you're
yeah.
talking about. I get it. And you get it back that this is ozone quality, and he was talking about land use. Okay, tomorrow, we're going to meet at 3 o'clock, HR 2910, Promoting Interagency Coordination for Review of Natural Gas Pipelines Act, HR 2883, Promoting Cross-Border Energy Infrastructure Act, and HR 218, King Cove Road Land Exchange Act. And I want to thank everybody for their attention to business tonight. The Rules Committee's finished its work for the evening.